let's unpack this. Today, we're diving deep into the history of one of the most powerful and, frankly, most fascinating institutions in American life, the United States Supreme Court.
Right.
You might picture the court today, the imposing building, those high-stakes, often dramatic decisions, the intense political battles over appointments. But the sources we're exploring for this deep dive, they reveal an institution with, well, incredibly humble beginnings, a surprising evolution, and a history that's far more complex and human than that marble facade might suggest.
That's absolutely right. And what's so striking, right from the start is how the court was perceived internationally compared to its almost, rudimentary reality in its early years.
How so?
Well, when Alexis de Tocqueville visited the U.S. back in the 1830s, he was genuinely astonished by the authority the founders had vested in the Supreme Court.
Oh, astonished.
He called it the most imposing judicial power never constituted by any people. He actually placed it at the head of all known tribunals. He was fascinated by its unique ability to decide disputes, not just between individuals, but crucially between individuals and the government. And even, as he put it, like when the state of New York versus the state of Ohio.
So state versus state, too.
Exactly. He saw something really fundamental in its role. He believed the peace, the prosperity, and the very existence of the Union are vested in the hands of the 7 judges.
That's such a powerful observation, especially from an outsider looking in. He saw this immense potential power, but the reality for those early justices sounds, a world away from today's life.
Oh, absolutely. Forget the robes and the permanent chambers for a moment. Our mission in this deep dive is really to pull directly from the source material you've provided, to give you a nuanced, detailed understanding of the court's past. We'll explore how it was established, the grueling realities of early service.
Yeah, I saw notes on that.
How its role and composition transformed over centuries, and how political dynamics weren't just some modern invention. They've always been interwoven with the court's story.
It's a journey that offers, I think, incredible context for understanding the court today. By seeing where it came from, the challenges it faced, the debates that shaped it, you get this shortcut to being truly well-informed, grounded in the historical record.
Yeah, the idea.
I'm excited to see what surprising nuggets these sources hold. So, where do we begin?
Let's start right at the very beginning, how the court was envisioned. And it's quite surprising to learn that when the Constitution was drafted and debated, there wasn't this huge dramatic fight over whether the Supreme Court would have the power to declare statutes unconstitutional.
Wait, really? No big fight?
The sources tell us that both supporters and opponents of the Constitution actually they assumed it would have this power, much like state courts already did.
They assumed it. That feels, counterintuitive to how we think of judicial review today.
Yeah.
It's such an enormous, potentially controversial power. What does that assumption tell us about their view of the Constitution itself?
It really highlights how central the idea of the Constitution as the supreme law was to their thinking.
Okay.
For supporters like Maryland Judge Alexander Conti Hansen, this judicial power was seen as a vital protection against Congress overstepping its bounds.
Right.
He argued that every judge in the Union will have a right to reject any act which he may conceive repugnant to the Constitution.
Makes sense.
And John Steele, at the North Carolina Ratifying Convention, he believed that if Congress passed unconstitutional laws, independent judges will not uphold them.
Right, that phrase, independent judges, that's key. And Alexander Hamilton in Federalist 78, he famously described the courts as this essential intermediate body between the people and the legislature.
Exactly.
Designed specifically to keep the legislature within constitutional limits.
Precisely. But, on the flip side, opponents also assumed this power would exist, but they saw it as a potential threat, a reason to fear the court would become too powerful.
Ah, okay. So the tension was there from the start.
Absolutely. That fundamental tension, the potential for the court to act as both guardian and potential overreach, it's present from the very beginning, and it echoes through his entire history.
And the case that famously articulated this power, maybe cemented it in the public consciousness, is Marbury v. Madison in 1803.
Yes. Chief Justice John Marshall, in that landmark opinion, declared, "Certainly all those who have framed written constitutions contemplate them as forming the fundamental and paramount law of the nation."
Powerful words.
And then came that indelible line stating it is emphatically the province and duty of the judicial department to say what the law is. His conclusion was just crystal clear. If a statute passed by Congress conflicts with the Constitution must govern.
So the power was assumed by the framers, debated by the ratifiers, and then explicitly laid out by Marshall. Okay, but while the institutional power was being defined, the day-to-day reality for the justices.
Well, it sounds incredibly rigorous, far removed from today's D.C.-based work.
Incredibly so. The original Judiciary Act required justices to ride circuit. Ride circuit. What did that involve?
It meant traveling vast distances for significant parts of the year to preside over lower federal courts alongside local judges. It was physically demanding, often dangerous, and pretty isolating.
Traveling by horse and carriage across huge circuits for months at a time, away from family. I mean, it sounds like a terrible burden.
It was, and they absolutely detested it. They persistently lobbied the other branches, Congress, the president, to be relieved of these circuit obligations.
They complained.
Oh, yeah. As early as the fall of 1790, just months into the court's existence, they sent a collective letter to President Washington pleading for relief.
What did it say?
They lamented having to pass the greater part of their days on the road and at inns and at a distance from their families. They were quite blunt, actually. They doubted that any set of judges, however robust, would be able to support and punctually execute such severe duties for any length of time.
Wow. That letter really paints a picture of the hardship. And it wasn't just the travel, right? Our sources mentioned they also objected strenuously to being asked to perform duties they saw as outside the judicial role, like deciding veterans' pensions under a 1792 statute.
Yes. This is another really crucial moment in establishing the separation of powers and the whole idea of judicial independence.
Okay.
Some justices, like Chief Justice John Jay and William Cushing, they reluctantly agreed to review the pension applications. But get this, they did so only as individuals, not in their capacity as judges. Because the decisions they made were subject to review by the Secretary of War and ultimately by Congress. And they saw that as fundamentally incompatible with judicial judgment.
So review by other branches was the sticking point, and others refused outright.
Yes, Justices James Wilson and John Blair refused to implement the statute at all. They believed it was unconstitutional precisely because it subjected judicial decisions to review by the executive and legislative branches.
They wrote to Washington about it.
They did. They insisted that their judgments could not be revised and controlled by Congress or executive officers. They called it radically inconsistent with the independence of that judicial power.
That early, firm pushback against external review is incredibly telling. It shows that right from the beginning, the justices had this strong sense of judicial independence, a core principle they were willing to fight for, even against Congress and the president.
And that tension, between the ideal of judicial independence and the reality of political influence, well, it's a constant theme throughout the court's evolution.
Okay.
Which brings us to how the court's role, its composition, and even the people on it have changed over time. And here's where we start seeing dynamics that sound, well, surprisingly familiar.
Like what?
The political calculations in selecting justices were absolutely not a modern invention.
You mean presidents trying to appoint people from their own party who shared their views, and senators trying to confirm or block based on politics, exactly like today?
According to the sources, yeah, the pattern is remarkably similar. Presidents tried to appoint justices from their party who shared their expected views, and confirmation was significantly easier when the president's party controlled the Senate. And the sources note that before the Civil War, if the Senate was controlled by the opposing party, they never confirmed a president's nominee in the final year of his administration.
Never. That is a striking historical parallel. It really challenges the notion that there was ever some past golden age of purely non-political Supreme Court appointments.
It certainly suggests that image is more myth than reality. Justices sometimes tried to time their retirements, to allow a like-minded successor to be appointed. But this was often thwarted by circumstances. Things like death, poor health, or crucially, the absence of a pension.
No pension, wow.
Yeah. Justice Henry Baldwin, for example, struggled with mental illness and died penniless, couldn't afford to retire. James Wilson, after financial troubles that included being in debtor's prison, suffered a stroke. The reality of the job was harsh, and retirement wasn't always a comfortable option.
Speaking of the individuals on the court, the early court was incredibly homogenous, wasn't it? Religiously, racially.
It was. Every nominee was Christian or Jewish for a very, very long time. There was only one Catholic justice before 1894, that was Roger Taney, who served from 1836 to 1864.
Taney, his nomination faced issues.
Oh, yeah. Andrew Jackson nominated him, and it actually faced significant prejudice at the time. The source quotes one religious paper referring to him as a Jesuit, accusing his order of seeking all the wealth and power in the universe, and stating his principles were diametrically opposed to every principle of liberty and justice.
That's intense.
And it would be many decades, not until 1916, before another Jewish nominee, Louis Brandeis, would join the court.
It's important to note that early lack of diversity and the prejudice some nominees faced. And, when we read about these early years, the history books often focus on the big landmark cases, Marbury, things like that. But were those the everyday reality for the justices?
That's another crucial correction from the sources. Great cases were exceedingly rare. Yeah. Most of the court's early work involved what the sources describe as humdrum disputes, cases that today's court would never even consider because they were, frankly, insignificant.
So not exactly high drama all the time.
Not at all. Reading only the famous cases can create this sort of hazy reverence, making it seem like this golden age when the justices were wise statesmen. While they occasionally did grapple with fundamental national questions, the sources say most of the time the Supreme Court was an ordinary court that decided banal legal disputes with no political implications.
That really gives us a more grounded picture of their actual work, slogging through a lot of routine legal issues. And many of the significant issues, even the great cases when they arose, often stem from the country's unique federal structure, right? That tension between states and the federal government.
Precisely. The U.S. began as 13 independent states that united while trying to preserve, much of their state sovereignty. This federal structure constantly raised questions about the division of authority.
Leading to cases.
Exactly. Generated many early cases and led to evolving interpretations of constitutional clauses, like the Contracts Clause, or the prohibition on states emitting bills of credit, essentially paper money.
And for marginalized groups within the U.S. at the time, like Native Americans and enslaved people, the court's decisions, while they often reinforced existing power structures and prejudices rather than challenging them.
That's a stark reality the sources highlight. Cases involving Native Americans in this period, they were not about equal rights. Discrimination was deeply ingrained.
So what were the cases about?
Instead, they revolved around who had the authority about private parties, states, or the federal government to override tribal sovereignty and property rights.
Oh, I see.
Take Johnson v. Emmentosh from 1823. Chief Justice Marshall's opinion laid out this principle rooted in European conquest, that European discovery vested ownership in the discovering nation.
And the Native Americans.
Indians, they said, had only a right of occupancy and were explicitly denied the power to sell their land. Marshall flatly stated that conquest gives a title which the courts of the conqueror cannot deny.
That's a profoundly disturbing justification of dispossession. Basically, might makes right.
It is. And regarding slavery, the sources are very clear. It was understood that states had the power to allow or forbid it.
So the court didn't question that?
No. The court's cases were generally confined to implementation details, never questioning the fundamental lawfulness of slavery itself. As Justice Woodbury said in Jones v. Van Zandt in 1847, the morality of slavery was considered a political question, one not for the court to decide.
A political question.
Wow. Yeah. Even in a case like the Amistad in 1841, which was a rare instance touching on the issue of enslaved people, the U.S. government controversially sided with Spain, arguing that captured Africans were pirates.
It's vital to remember that the court, for much of its history, wasn't a champion of equal rights for all. It often reflected and upheld the prevailing discriminatory norms of American society. This makes the later rights revolution, well, all the more remarkable.
Which sets the stage perfectly for the mid-19th century, the period leading up to and including the Civil War. And the infamous Dred Scott v. Sanford decision in 1857 is a crucial pre-war case.
Ah, yes, Dred Scott. The decision that Chief Justice Taney authored, which effectively opened the West to slavery and dismantled those fragile political compromises.
Exactly. And the sources point out a striking detail. Taney's extensive discussion on Congress's power in the territories was arguably, unnecessary for resolving the case itself. He noted at the very end of the opinion that Scott's status upon returning to Missouri was governed by Missouri law anyway. But the court pressed ahead with its broad, devastating ruling on federal power.
During the war itself, President Lincoln made several appointments to the court.
Yes, including Stephen Field and Noah Swain. These were generally younger men who would end up having long tenures.
And Taney?
Chief Justice Taney remained on the court despite worsening health and facing poverty. He'd invested his savings in worthless Confederate bonds.
Oh, wow.
He stayed until his death at 87 in 1864, needing support from the Supreme Court bar for his daughters afterward because, again, there was no pension system for justices back then.
And his replacement.
Salmon Chase, a prominent anti-slavery advocate, his incredibly swift confirmation within hours was only possible because the Southern states had seceded and weren't represented in the Senate.
So the politics were clear.
Very clear. There was an expectation he would uphold war policy. We see this debated in the prize cases of 1863 concerning the Union's blockade. Justice Nelson, dissenting, argued a formal declaration of war was legally needed to justify seizing ships.
So even during wartime, fundamental legal debates about the scope of executive power were playing out right there on the court. After the war, Reconstruction brought intense conflict between President Andrew Johnson and Congress, and the court found itself in the crossfire.
It really did. In a pretty blatant move to prevent Johnson from appointing any justices who might oppose the Reconstruction policies, Congress explicitly shrank the court.
Shrank the court? How?
They passed a statute in 1866 reducing it from 10 justices down to 7 through attrition, just letting seats go unfilled when justices left.
And the motivation was explicitly political.
Absolutely. The sources quote Chief Justice Chase and Justice Davis supporting this. Davis wrote to his brother-in-law that the bill was passed simply to prevent the president from appointing Supreme judges.
You can't get much clearer evidence of political motivation influencing the actual structure of the court.
Nope. And amidst all this political maneuvering came significant Reconstruction-era cases, like Ex parte Milligan in 1866.
This is the important case about civilians being tried by military commissions, right?
Yeah.
Away from the battlefield.
Right. And crucially, all 9 justices agreed that Milligan's trial by military commission was unlawful because the civilian courts were open and functioning in Indiana, where he was arrested.
What was the reasoning?
Justice David Davis, writing for the majority, noted that now that the public safety is assured, this question can be discussed and decided without passion. The core ruling was clear. Civilians cannot be tried in military courts where regular courts are available. The Constitution guarantees trial before a normal court with a jury.
But they made a distinction for war zones.
Yes, they distinguished this from actual rebellion zones where civil authority was overthrown.
And yet the court declined to intervene directly against President Johnson himself in the case of Mississippi v. Johnson in 1867.
That's right. A unanimous court held it could not issue an injunction against the president to stop him from administering the Reconstruction Acts.
Why not?
Chief Justice Chase explained the distinction. While courts could intervene in purely ministerial acts like, delivering a signed commission, they couldn't enjoin executive and political acts related to governing the South. He cited the impropriety of such interference.
So a reluctance to directly confront the executive branch on core policy, especially during such a tense political period.
Exactly. Meanwhile, beyond these high-profile cases, the sheer workload facing the court was, it was ballooning after the Civil War.
Getting overloaded.
It exploded. The sources mention Figure 5.3 illustrates this dramatically. The existing system, with justices still having those circuit duties, was becoming unsustainable.
So what do they propose?
There were proposals to add more justices or even divide the court into sections, but Congress chose a different path with the Judiciary Act of 1891.
The 1891 Act, what did it do?
It created a new 3-tier system with intermediate circuit courts of appeals.
This is a major structural change, wasn't it?
Huge. These new intermediate courts basically absorbed appeals that used to go straight to the Supreme Court.
So it reduced the Supreme Court's load?
Dramatically. It reduced its mandatory caseload, shifting its focus away from those humdrum disputes we talked about earlier. Now it would primarily hear appeals from the new circuit courts of appeals. It fundamentally changed what kind of cases the court would spend most of its time on.
And it's interesting to see that even as other conflicts raged, the court saw a degree of maybe national reconciliation in appointments after the war.
That's a fascinating point the sources raise. Subsequent Southern justices were appointed without major controversy, even some who had fought for the Confederacy, like Howell Jackson and Edward White.
Really? Former Confederates?
Yes, and Horace Lurton, appointed way later in 1909 at age 65, was the last justice with any role on either side of the Civil War.
It suggests maybe a deliberate effort to symbolically knit the nation back together on the highest court, even if racial divisions persisted elsewhere.
It's a fascinating detail, yeah.
Okay, speaking of the day-to-day life during this period, Section 4 covers the era from roughly 1870 to 1930. The justices finally became permanent residents of Washington, D.C., after the 1869 Act increased the court's size. But they still largely worked from home offices.
That's a crucial point. The idea of all the justices working together in one building is actually relatively modern. Documents flowed back and forth between their homes.
How'd that work?
While each justice was assigned a messenger, and the sources say these messengers quickly became all-purpose valets and essentially household servants because their duties were performed right there in the justices' homes.
Like butlers.
Pretty much. Justice William Burnham Wood's complaint sounds both amusing and utterly frustrating. He said about his messenger, "First man I see in the morning and the last man I see at night. He haunts me all the time. That fellow will be the death of me."
That gives you a vivid, almost comical picture of the informal, sometimes intrusive nature of early court life. This era is also when law clerks were introduced, right? Starting around 1886.
Yes, but their role was very different from today. Even clerks who were law school graduates performed secretarial tasks because justices didn't have dedicated secretaries.
So typing and dictation.
Yeah. Justice Charles Evans Hughes, who apparently hated writing longhand, would dictate to his clerks. Their duties, as mentioned by a clerk named Charles Wilson, included examining petitions and motions, sometimes writing factual statements for submitted cases, but also stenography and handling the justice's private business.
Handling private business.
Seems so. Francis Biddle's account of clerking for Justice Holmes involves balancing his checkbook and listening to his tall talk, while Holmes himself still did his core work, checking citations and writing opinions in longhand.
And Holmes had preferences for his clerks.
Apparently, he preferred unmarried men because they had no competing obligations.
So clerks were more like highly educated assistants than the legal powerhouses they're often seen as today. And the sources reveal some pretty stark details about the social biases present in the selection process for these early clerks.
This is a really revealing glimpse into the pervasive prejudices of the time. The clerkships were largely filled by white men from elite law schools. It was a very clubby world.
How do we know?
Well, the correspondence between Justice Harlan Fiske Stone and the dean of Columbia Law School, young Berryman Smith, is quite telling. Dean Smith would describe student social characteristics right alongside their academic merits.
Oh, dear.
Examples. In 1931, recommending Herbert Wechsler, who was Columbia's top student, Smith assured Stone that, although he is a Jew, he is a very agreeable person.
Wow.
A few years later, cautioning Stone about another Jewish candidate, Smith noted the student was not offensive, but at times exhibits a lack of tact.
That correspondence is really striking. It highlights the subtle but clearly present biases in the selection criteria, even for these early, relatively low-level positions.
It shows how deeply ingrained these societal prejudices were, even within the supposedly meritocratic world of elite law schools and the Supreme Court.
Okay. This period, roughly from the end of Reconstruction through the early 20th century, is also known as the Jim Crow court era because of the court's role in undermining Reconstruction and upholding segregation.
That's right.
How did the court contribute to establishing and maintaining segregation during this time?
Well, after the political environment shifted in the 1870s, particularly with Democrats regaining control of the House, there was really no expectation of new civil rights legislation coming from Congress.
And the court reflected that.
Its decision certainly did. Cases like United States v. Reese, United States v. Cruikshank, and United States v. Harris, decided between 1876 and 1883, interpreted the Civil War amendments incredibly narrowly.
How so?
They focused only on prohibiting state action, not the actions of private individuals. This effectively killed off the federal enforcement of voting rights in the South for nearly a century.
So when Congress passed the Civil Rights Act of 1875, attempting to prohibit discrimination by private businesses like hotels and theaters,
The court struck it down, yes, in the civil rights cases of 1883.
what was the reasoning there?
Justice Bradley, writing for the court, argued that the 14th Amendment only authorized Congress to legislate against state laws or officials. He stated that the wrongful act of an individual was simply a private wrong that the states were responsible for handling.
But the states weren't handling it.
That was the profound irony. Southern states had no laws prohibiting private race discrimination. In fact, their laws often required it.
And then, perhaps most famously, came Plessy v. Ferguson in 1896.
The landmark decision upholding state-mandated racial segregation under the doctrine of separate but equal.
But we should remember Harlan's dissent.
Absolutely. It's crucial to remember Justice John Marshall Harlan's powerful dissent, where he declared the Constitution was colorblind. His voice, while a minority at the time, certainly echoed later in the century.
The sources also showed that this idea of white superiority wasn't confined to domestic race relations, but was also evident in cases involving territories acquired after the Spanish-American War, the Insular cases.
The Insular cases in 1901 are a prime example. The court essentially wrestled with the question of whether residents of places like Puerto Rico or the Philippines, and the court's language described them as being populated by people, whether savages or civilized, could automatically be entitled to all the rights, privileges, and immunities of citizens under the Constitution.
And the answer was no.
Ultimately, the court found that the Constitution did not fully protect the non-white residents of these territories.
Even Harlan's dissent wasn't based on equality.
Even Justice Harlan's dissent in these cases, while opposing annexation without constitutional protection, wasn't really rooted in a principle of racial equality. It was more his view that the U.S. shouldn't have annexed places populated primarily by non-whites if they couldn't be safely brought within the operation of the Constitution.
These cases are difficult to read today, but they underscore how prevalent racist ideologies were at the turn of the 20th century and how they were reflected even in the highest court's interpretations of fundamental rights.
Indeed. Moving into the early 20th century now, the court became particularly well known for frequently striking down economic regulations passed by states and the federal government. This period is often referred to as the Lochner era.
Right, Lochner. What was driving the justices to invalidate so many regulations during this time? Fear of socialism.
The sources explain a few motivations. Some justices held genuinely hostile views towards government regulation, fearing that socialism was at the gates. They worried about the growth of concentrated federal power and saw the court as sort of the last line of defense against these trends.
Like Taft.
Chief Justice William Howard Taft, who served after this era but shared some of its sensibilities, famously confided to his brother, "I must stay on the court in order to prevent the Bolsheviki from getting control." Maybe half in jest, but revealing of the anxieties.
They weren't necessarily inventing new constitutional theories from scratch, right? But applying existing ones in a certain way.
Exactly. They drew on legal traditions that emphasized individual liberty and property rights, but applied them in a manner that produced results consistent with their belief that extensive government regulation was unsound or dangerous.
So they thought they were upholding the Constitution.
While it seems strange to us today, when things like minimum wage and maximum hour laws are standard, the justices at the time could sincerely believe they were upholding fundamental law by striking down these measures. As Justice Stanley Matthews put it, without the courts to check legislative power, everything we hold to be dear and sacred as personal right is at the mercy of a monarch or a mob.
Lochner v. New York in 1905 is the case that gave this era its name, the Baker Hours case.
Yes, the court struck down a New York law limiting the working hours of bakers, finding it violated a supposed liberty of contract.
And Holmes dissented famously.
Justice Oliver Wendell Holmes Jr.'s famous dissent accused his colleagues of reading their own economic theories, specifically laissez-faire principles, into the Constitution. But the sources add some nuance here. The court didn't prohibit all government intervention in the economy. They were more likely to strike down laws they saw as playing favorites, or benefiting one specific group at the expense of another. For example, they had earlier upheld a Utah law regulating mining hours in Holden v. Hardy, seeing mining as a particularly dangerous industry justifying regulation.
Okay, so it wasn't a total block on regulation, just certain kinds they disliked. Another significant economic ruling from this period was the invalidation of the federal income tax in the Pollock cases of 1895.
This was quite a turnabout. The court had earlier unanimously viewed only capitation taxes, head taxes, and real estate taxes as direct taxes requiring apportionment among the states.
Apportionment meaning based on state population.
Right, which was impractical for an income tax. But in Pollock, the court shifted. It held that a tax on income derived from real estate, and later from other property like stocks and bonds, was also a direct tax requiring apportionment.
What about income from wages?
The initial decision on taxing other income, like wages, split 4-4. But after re-argument, when Justice Jackson could participate, it became a 5-4 decision invalidating the entire income tax, even the tax on wages. They felt they couldn't easily sever the parts they deemed unconstitutional.
So for a time, the court effectively blocked the federal government's ability to levy a broad income tax. That required a constitutional amendment later, right?
Exactly, the 16th Amendment. Meanwhile, the problem of the court's ballooning caseload, even after that 1891 act, hadn't entirely gone away.
Still too many cases.
It hadn't completely solved it. And Chief Justice William Howard Taft, who served from 1921 to 1930 after being president, played a major role in addressing it.
Taft the lobbyist.
He was an active lobbyist for legislation concerning the court, remarking, "I don't think former Chief Justices had so much to do in the matter of legislation as I have." His major accomplishment was advocating for the Judiciary Act of 1925, often called the Judges' Bill.
And this act was absolutely pivotal in shaping the modern Supreme Court, right? Giving them control over their docket.
It was transformative. It gave the court almost complete discretionary control over its docket through the writ of certiorari.
Certiorari, meaning they choose their cases.
Exactly. Certiorari is the formal term for the court choosing which cases it wants to review. This allowed the justices to decide which cases to hear, enabling them to filter out the less important disputes and focus on cases of national significance or those involving important questions of federal law.
Taft wanted that filtering power.
He did. Taft himself emphasized the need to filter appeals, especially, as he put it, the frivolous appeals attempted then in that covered by so-called constitutional questions.
Speaking of Taft and his era, the court finally got its own dedicated building in the 1930s. The sources mention a photo illustrating Justice Owen Roberts still working from his summer home on a dairy farm, highlighting how decentralized their work was before the building.
Yes, the Grand Marble Palace was built in the 1930s. Figure 6.5 in the sources shows it. And surprisingly, the justices at the time were initially quite reluctant to move in.
Reluctant to move into the palace.
Yeah. They had grown accustomed to working from their home offices and weren't thrilled about the opulent new building. Justice Brandeis joked about the running ice water and shower bath he never uses in his new chambers.
Huh?
Harlan Fiske Stone called the building bombastically pretentious and a mausoleum. Cardozo and Brandeis even joked about having to enter on white elephants or stilts because of its grandeur.
So who actually moved in?
Only Justices Sutherland and Roberts moved in right away. It actually took new appointments, justices who were more accustomed to working in offices, to fully populate the building's chambers.
That's a wonderful anecdote that brings the human element into the story of this iconic building. It wasn't universally welcomed by the justices who would first inhabit it.
It really emphasizes how much of a shift it was from their prior way of working, and those shifts continued into the birth of what we might call the modern court. This is a period marked by major changes in how the court dealt with individual rights and government regulation, particularly starting around the New Deal era. During World War I, for instance, the federal government significantly ramped up its efforts to punish speech it deemed harmful, using the Espionage Act of 1917.
And the court largely went along with that, didn't it, like in Schenck?
It did. In Schenck v. United States in 1919, the court unanimously upheld the convictions of individuals who distributed anti-conscription leaflets.
That's where the clear and present danger test comes from.
Exactly. Justice Holmes, writing the opinion, introduced it, stating, "The question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent."
But he added a wartime caveat.
Yes, a crucial one. When a nation is at war, many things that might be said in time of peace are such a hindrance to its effort that their utterance will not be endured. They also unanimously upheld the conviction of Eugene Debs a week later.
So, wartime necessity, in the court's view at the time, significantly curtailed speech that would normally be protected. But we see a different kind of intervention starting to emerge in the 1920s, this time in state criminal cases.
This is a major development. It signals a new willingness by the court to scrutinize state court proceedings. Starting in the 1920s, the court began reversing unfair state criminal convictions on constitutional grounds. Moore v. Dempsey in 1923 is cited as the first significant instance.
What happened in Moore?
It involved 5 black men convicted in a trial in Arkansas that was completely dominated by a hostile mob. The defense lawyer was too terrified to call witnesses, and the jury deliberated for less than 5 minutes.
Holmes's description of that trial environment is incredibly powerful.
Right.
No juryman could have voted for an acquittal and continued to live.
Exactly. Despite the Arkansas state courts upholding the convictions, the Supreme Court reversed them. Holmes wrote that if the whole proceeding is a mask swept to a fatal end by an irresistible wave of public passion, the court could intervene to secure constitutional rights.
So this was the first time they reversed a state criminal conviction on due process grounds.
Yes. The first time based on a violation of constitutional due process. a significant departure and a precursor to later developments in criminal procedure.
And interestingly, even though presidents in the 1920s and early 1930s like Coolidge and Hoover were conservative Republicans, their appointments were actually shifting the court's ideological balance.
Yeah, the sources note that the justices leaving the court during this period were generally more conservative than the incoming ones under Coolidge and Hoover. So it moved the court, perhaps inadvertently for those presidents, decisively to the left.
Setting the stage for the New Deal confrontations.
Exactly. Which is where we see the court's role in regulating the economy really tested. FDR's ambitious New Deal programs faced immediate legal challenges.
But initially, the court seemed okay with some of it.
They did. Initially, in early 1934, cases like Home Building and Loan Association v. Blaisdell and Nebbia v. New York saw the court approving government regulation of the economy in ways it likely wouldn't have in the Lochner era.
People notice.
Yeah. This led contemporary observers and the press, like the New York Times and Literary Digest, to predict a constitutional revolution of 1934. The Gold Clause cases in February 1935 also went for the administration. One senator noted that it seemed the court had shifted from protecting private property against the government to supporting the government against citizens.
But then came that famous sudden shift in direction in late 1935 and 1936. The court started striking things down.
Yes, the court began consistently striking down key New Deal programs in cases like Panama Refining, Schechter Poultry, the Sick Chicken case, and Carter v. Carter Coal Co.
And that led to the court packing plan.
Exactly. This series of losses for the administration led directly to FDR's controversial court packing plan proposal in 1937. He proposed adding justices to the court to get a more favorable judiciary.
But it failed.
It ultimately failed due to widespread opposition, even from within his own party.
But 1937 is also the year of the famous switch in time that saved 9, or at least that's how the story is often told. What was the key case?
The pivotal case was NLRB v. Jones and Laughlin Steel Corp. In April 1937. The court upheld the National Labor Relations Act, a cornerstone of the New Deal.
How did they justify it, given the earlier rulings?
Chief Justice Charles Evans Hughes wrote the majority opinion. He found that while manufacturing or production itself might not be commerce, it wasn't separable from commerce if it affected it. This represented a new, broader view of Congress's power under the Commerce Clause.
And the dissent from the conservative justices, often called the Four Horsemen, was incredibly strong. McReynolds.
It was fierce. Justice McReynolds, writing for the dissenters, argued this decision allowed Congress to regulate nearly everything because, as he put it, almost anything, marriage, birth, death, may in some fashion affect commerce.
And he added things from the bench.
Yes. The sources highlight this specific dramatic moment. McReynolds actually added material while announcing his dissent from the bench, including vivid questions about whether regulating pigsties and wheat fields was now constitutional under the Commerce Clause, and asking pointedly, are our states obliterated?
Wow. Announcing a dissent and adding impromptu, fiery questions from the bench. You can really feel the tension and frustration of that moment. It truly signals a fundamental shift was underway, a new era of deference to legislative power in economic matters.
Absolutely. And following the shift, FDR went on to make 7 appointments to the court between 1937 and 1941.
Well, allies.
They were all political allies, and many, like Hugo Black, had no prior judicial experience. FDR explicitly stated he wanted progressives on the bench who will remain progressives.
Hugo Black's appointment was particularly controversial at the time, wasn't it? He was a former senator and had been a member of the Ku Klux Klan earlier in his life.
It was very controversial, yes. And his initial lack of judicial experience apparently showed. The sources mention Justice Harlan Fiske Stone had to gently correct Black's early mistakes, even writing opinions himself to guide him.
But he became influential.
He did. Black is a fascinating figure who overcame this rocky start and his problematic past to become one of the court's longest-serving justices and a strong defender of civil liberties, particularly First Amendment rights.
Even with these shifts towards a more progressive bent and greater deference to government power, the court wasn't always a defender of individual rights, especially during wartime. Hirabayashi.
That's a crucial point. The pressures of national security can sometimes override civil liberties concerns on the court. In Hirabayashi v. United States in 1943, for instance, the court unanimously upheld the curfew order against Japanese Americans during World War II.
This was part of the broader pattern that led to the internment of Japanese Americans. What was the court's reasoning?
Yes. Justice Stone's opinion in Hirabayashi deferred heavily to military judgment. He stated it was not for any court to sit in review of the wisdom of their action.
Deferred to the military?
And he endorsed the military's imposition of the curfew based on fears of sabotage and espionage, and made assumptions about the loyalty of Japanese Americans. He cited a long history of anti-Japanese prejudice that supposedly prevented assimilation and the existence of private language schools that were thought to cultivate allegiance to Japan.
Even though Hirabayashi was a U.S. citizen.
Yes, he was a U.S.-born citizen who deliberately violated the curfew as a test case challenging its constitutionality.
That case stands as a sobering reminder that even during periods of relative progress, the court's protection of rights can be fragile when confronted with national security fears and ingrained prejudice.
It highlights the complex and sometimes contradictory path of the court's history.
And those complexities certainly carried into what's often called the Warren Court era, a period seen as the rights revolution. What factors contributed to the court's new receptiveness to individual rights after World War II?
Several factors came together, according to the sources. First, the end of mandatory circuit riding and the resulting weakening of regional representation meant the court was no longer majority Southern. That made it institutionally easier to confront issues like segregation.
Okay.
Second, the discretionary control over the docket gained through the 1925 Judiciary Act was crucial. It allowed the court to select key cases and effectively create new rights like school desegregation without being overwhelmed by a flood of appeals.
Control is key.
Third, FDR's appointments had filled the court with justices who were generally more open to arguments for racial equality and individual liberties. And finally, the court had already begun to incorporate some rights from the Bill of Rights against the states through the 14th Amendment's Due Process Clause in earlier decades, so the Warren Court could expand on this foundation.
And external groups played a vital strategic role in bringing cases to the court, like the NAACP.
Absolutely. Organizations like the NAACP and its Legal Defense Fund, the LDF, developed sophisticated legal strategies. They brought test cases to the court, starting with challenges to all white juries in the Scottsboro cases, which laid crucial groundwork for later, bigger challenges.
Which brings us to Brown v. Board of Education, the school desegregation case.
This wasn't just a single case, remember. It was actually 4 consolidated cases brought by the LDF challenging segregated public schools in Kansas, South Carolina, Virginia, and Delaware.
And their argument.
The LDF presented a 2-level argument. Either the court should outright overrule Plessy v. Ferguson, or even under the separate but equal standard, these specific schools were unequal and violated the Constitution.
Did the government weigh in?
Yes, the federal government filed an important amicus brief, a friend of the court brief, urging the court to find state-sponsored segregation unconstitutional.
The oral arguments must have been incredible. Marshall versus...
They featured legal titans. On one side, Thurgood Marshall and his colleagues from the LDF. On the other, defending segregation in the South Carolina case was John W. Davis, a legal giant, former Solicitor General, Democratic presidential candidate. In 1924, it was his final argument before the court.
Wow.
Arguing the Kansas case was a much younger lawyer, Paul Wilson, in his very first appellate case.
And a crucial factor was the appointment of Earl Warren as Chief Justice in 1953, just before Brown was decided.
President Eisenhower appointed him, and there was certainly skepticism. Warren was a politician, a former governor of California, not a judge.
People were critical.
Critics like William Rehnquist, who clerked that term and would later be Chief Justice himself, saw it as a political deal. Rehnquist wrote a critical letter to Eisenhower suggesting maybe he should have been appointed a general in the Army instead. Yet Warren became a transformative Chief Justice.
And the court's eventual unanimous decision in Brown v. Board of Education in 1954, declaring state-sponsored segregation in public schools unconstitutional, was monumental.
It was. Though the follow-up decision in Brown II in 1955, requiring desegregation to proceed with all deliberate speed, led to fierce resistance across the South, the massive resistance.
All deliberate speed wasn't very fast.
It wasn't. Chief Justice Warren was reportedly optimistic, joking that the traffic light will have changed from brown to green, but the reality was very different. Georgia's governor lowered the flag to half-staff in protest.
And the court had to keep addressing it.
Yes. The court continued to tackle desegregation in subsequent cases, approving busing as a remedy to achieve integration where residential patterns caused segregation in Swan v. Charlotte Mecklenburg in 1971. Chief Justice Burger wrote in that case that all things are not equal in a system that has been deliberately constructed and maintained to enforce racial segregation.
The Warren Court became known for its activism in protecting individual rights, sometimes clashing with older justices, like Frankfurter.
Yes, particularly with Justice Felix Frankfurter. He had been a progressive earlier in his career, but his position of judicial deference to the legislature became the conservative stance in this new era of rights-focused judicial activism.
He got bitter.
He grew increasingly bitter in his later years on the court, complained about a disregard for law, and found Chief Justice Warren's style crude, heavy-handed, repetitive moralizing.
Ouch.
The sources note he sometimes spilled his bitterness into public remarks during oral announcements, saying Warren's style was like eating rancid butter.
Beyond race, the court also shifted its stance on free speech, moving away from the more restrictive views seen during the WWI and early Cold War years, the McCarthy era.
Yeah, the early 1950s saw decisions like Dennis v. United States upholding convictions simply for belonging to organizations that advocated for revolution, even if they weren't actively planning it.
But that changed.
Starting in the mid-1950s, there was a push within the court for a new look at these cases.
Yeah.
Justice Harlan mentioned this, likely influenced by reflection on the McCarthy era and the complexities of the Cold War. The court gradually moved towards offering greater protection for speech.
And the Warren Court is perhaps most famous for its revolution in criminal procedure rights. Mapp, Gideon, Miranda.
Key decisions from this era fundamentally changed policing. And the criminal justice system in the U.S. Mapp v. Ohio in 1961 established the exclusionary rule, meaning illegally seized evidence couldn't be used in state criminal trials.
Right.
Gideon v. Wainwright in 1963 guaranteed the right to court-appointed counsel for indigent defendants in felony cases.
Huge impact.
And Miranda v. Arizona in 1966 required police to inform suspects of their rights, right to remain silent, right to an attorney before custodial interrogation.
The Miranda warnings. These were highly controversial at the time, but had a massive lasting impact.
Absolutely. They also took on the complex relationship between church and state during this time.
How so?
Moving away from an earlier historical understanding where Protestant Christianity was often intertwined with government. The court had even declared at one point that this is a Christian nation.
Really?
But the 1960s and 70s saw cases that granted new rights to religious dissenters and began moving the court towards a principle of government neutrality regarding religion.
Okay, so after the Warren Court, we see the pendulum beginning to swing back in terms of judicial philosophy and outcomes. Republican appointments start.
Absolutely. The period from 1969 to 1991 saw 10 consecutive justices appointed by Republican presidents Nixon, Ford, Reagan, and George H.W. Bush.
10 in a row.
Yep. Notably, Jimmy Carter was the only president in history to serve a full term without making an appointment during this time.
And the goal was?
The stated goal of many of these appointments was explicitly to undo the court's work of the 1960s and early 1970s.
And the appointment and confirmation processes themselves became increasingly contentious during this era. Fortas's replacement.
We saw struggles replacing Justice Abe Fortas. Two Nixon nominees, Clement Haynsworth and G. Harold Carswell, failed confirmation due to opposition and ethical concerns. This highlighted a shift in acceptable ethical standards for nominees.
And then Clarence Thomas.
And the confirmation of Clarence Thomas in 1991, with the highly public and controversial Anita Hill hearings captured in Figure 14.2 in the sources, made him instantly recognizable to the public. While he faced significant criticism, he went on to become one of the longest-serving justices.
This new conservative majority didn't always outright overrule the Warren Court's major decisions, did they? But they often limited their reach.
That's an important distinction. They didn't typically overturn landmarks like Miranda, but subsequent cases significantly narrowed its application.
Oh.
For example, Harris v. New York in 1971 allowed prosecutors to use confessions obtained in violation of Miranda to impeach a defendant who testified differently. Chief Justice Burger wrote that Miranda's shield cannot be perverted into a license to use perjury.
Other exceptions.
Other cases recognized a public safety exception to the warning requirement and allowed a second warned confession even if an initial unwarned confession had been obtained. Oregon v. Elstad, 1985. Justice Brennan, a Warren Court liberal, worried that these decisions undid much of the progress of Miranda.
A similar pattern of narrowing protections emerged regarding the Free Exercise Clause, the one protecting religious practice.
Yes. Earlier cases had sometimes exempted religious minorities, like the Amish, from certain generally applicable laws like compulsory school attendance.
But that changed under Burger.
But later cases, including decisions from Chief Justice Burger, required the Amish to pay Social Security taxes and rejected a Native American father's religious objection to obtaining a Social Security number for his daughter. Berger's tone in some of these cases was described as verging on exasperation.
What was his argument?
He argued the clause protected people from government compulsion, not a right to dictate the conduct of the government's internal procedures. The idea that religious minorities were constitutionally entitled to exemptions from general laws was, as the sources put it, hanging by a thread.
Looking at the court's composition, while there have been some steps towards greater representation in recent decades, the sources also highlight historical open secrets that reveal complexity around diversity, like sexuality.
The sources note the historical lack of openly gay justices and mention Frank Murphy, who served from 1940 to 1949 as an open secret within Washington circles.
What does that mean?
He cultivated a public image with women, but insiders reportedly joked about his sexuality. Journalist Drew Pearson was quoted as saying, "There's no place where you could be safer with him."
And the process for confirming justices in the Senate became much more formalized and often intensely partisan during this period, meeting with senators.
The Nixon administration really inaugurated the practice of nominees meeting individually with senators, particularly members of the Judiciary Committee, especially after the failures of Haynsworth and Carswell.
O'Connor's binder.
Sandra Day O'Connor's binder for her 1981 confirmation meetings is a clear example, reportedly filled with notes on senators' interests and warnings about potential opponents like Senator Ted Kennedy. It became a highly choreographed political process.
And the sources point to something quite striking about the modern court: the increasing alignment of justices' votes with the political party of the president who appointed them.
This is a defining feature of the contemporary court. While justices have always divided politically, there wasn't always a perfect alignment between party affiliation and voting patterns throughout history.
But now,
However, the sources note that since the retirements of Justice Byron White, the last conservative Democrat, in 2002, and Justice John Paul Stevens, the last liberal Republican, in 2010, well, the court's lineup has strongly resembled Congress.
how so?
Every Democratic appointee is ideologically to the left of every Republican appointee.
This ideological sorting seems particularly evident in areas like religion and campaign finance, Establishment Clause cases.
Yes. On the Establishment Clause concerning separation of church and state, the court has shifted towards a view of neutrality, holding that the government must provide the same assistance to religious organizations as it does to secular ones.
Like school vouchers.
Cases like Zellman v. Simmons-Harris in 2002 upheld school vouchers used at religious schools. Chief Justice Rehnquist found the program neutral. Trinity Lutheran Church v. Lohr in 2017 allowed religious schools access to playground funds. And Espinoza v. Montana Department of Revenue in 2020 required scholarships for private schools to include religious ones,
And these are close votes.
often decided by narrow 5-4 votes strictly along party lines.
And campaign finance law has seen major shifts based on First Amendment interpretations by the court. Citizens United.
Cases like Citizens United v. FEC in 2010 held that independent political spending by corporations and unions is protected free speech. And McCutcheon v. FEC in 2014 struck down aggregate limits on campaign contributions.
What was Roberts' reasoning?
Chief Justice Roberts, writing for the majority in McCutcheon, defined corruption very narrowly, essentially as the literal exchange of money for political favors, like bribery. He argued that restricting contributions denied expressive and associational rights.
And the dissent.
Justice Breyer dissented forcefully, arguing for a broader view of corruption related to maintaining the integrity of our public governmental institutions. The sources frame this as the First Amendment shifting from protecting the voices of the weak to ensuring the political power of wealth.
That's a provocative way to look at how the interpretation of a fundamental right can evolve and impact society. And on equal protection, the use of that clause from the 14th Amendment has also seen a significant reversal, used more for white plaintiffs now.
Indeed. Once the primary constitutional basis for securing rights for Black Americans, the Equal Protection Clause is increasingly being used as a source of rights for white people, particularly in challenges to affirmative action or policies aimed at promoting racial diversity.
Like the Seattle schools case.
In Parents Involved in Community Schools v. Seattle School District No. 1 in 2007, a 5-4 majority, led by Chief Justice Roberts, held that school districts violated white children's rights by considering race in student assignments to achieve racial balance.
What was the limit, they said?
And the majority argued that race could only be used to remedy past intentional discrimination, not simply for the sake of achieving racial balance itself.
And perhaps the most intensely debated and politically charged issue in recent decades has been abortion rights, starting with Roe.
The history of abortion rights at the court began with Roe v. Wade in 1973, which established constitutional right to abortion. This decision immediately sparked intense debate that has continued for decades.
And Casey reaffirmed it, but modified it.
Planned Parenthood v. Casey in 1992 saw a 5-justice coalition reaffirm the core right established in Roe, though they modified the legal standard, introducing the undue burden test. But the sources highlight how the balance on the court was precarious and depended on future appointments.
O'Connor's retirement was key.
The retirement of Justice Sandra Day O'Connor and the appointment of Justice Samuel Alito provided the crucial 5th vote to uphold a federal ban on what opponents call partial birth abortion in 2007. That signaled a potential shift,
Leading ultimately to the dramatic Dobbs v. Jackson Women's Health Organization decision in 2022, overturning Roe.
Yes, in Dobbs, the court explicitly overruled Roe and Casey. It eliminated the federal constitutional right to abortion and returned the issue entirely to the states. Justice Alito wrote the majority opinion.
And the dissenters.
The sources also highlight the perspective of the dissenting justices. They emphasize the half-century of reliance by women on the rights established in Roe and Casey and describe the decision as an immense loss of women's power, control, and dignity.
The reactions were intense.
Oh, incredibly intense. The sources capture reactions from both sides, ranging from calling it an answer to a prayer to devastating in a worst-case scenario. Law professor Reva Siegel is quoted saying the justices' efforts to hide their views about abortion in a story about the Constitution's history and traditions reveals to us their view of women.
And the sources are clear. Dobbs didn't end the debate.
Not at all.
But just a few years before Dobbs, the court established another major new right that significantly impacted millions of Americans: same-sex marriage.
In Obergefell v. Hodges in 2015, a 5-4 decision authored by Justice Anthony Kennedy established a constitutional right to same-sex marriage.
Kennedy's reasoning.
He emphasized that there was no difference between same-sex and opposite-sex couples regarding the fundamental right to marry, and that denying same-sex couples that right caused harm and instability.
Did he address tradition?
He acknowledged that the decision departed from historical tradition, but argued that constitutional rights should not be defined only by past practice.
Scalia dissented sharply.
Justice Scalia wrote a very sharp dissent, scoffing at the majority's reasoning and predicting that the only limit on the court's power was its sense of what it can get away with.
In recent years, the court has also been directly involved in cases arising from the actions of President Trump, and here again, the sources highlight how clear the political alignment has become.
Yes, cases arising from the Trump presidency often saw Justices Thomas and Alito voting favorably towards the administration, the 3 Democratic appointees voting against, and the other justices sometimes splitting depending on the specific case.
And the sources mention Virginia Thomas.
Yes, they mentioned Virginia Thomas, Justice Thomas's wife, urging Republican state legislators to switch electoral votes after the 2020 election, and her testimony that she believed the election was stolen.
And finally, a fascinating recurring theme throughout the court's history that is still discussed today is the idea of jurisdiction stripping. Congress taking away the court's power to hear certain cases.
This is when Congress considers passing legislation to remove the Supreme Court's ability to hear certain types of cases, usually when Congress strongly disagrees with the court's decisions in that area.
It's happened before.
The sources give historical examples. Senator Jenner proposing it in 1957 after some Red Monday free speech decisions, Congressman Tuck after reapportionment cases, and bills considered after Miranda regarding confessions.
And the most famous example.
The most famous historical example was after the Civil War. Congress, fearing the court would strike down Reconstruction legislation, specifically removed the court's habeas corpus jurisdiction to prevent it from reviewing the constitutionality of the Military Reconstruction Acts.
And it's still discussed.
This idea is still discussed today, particularly by some lawmakers after the Dobbs decision.
So, wow, we've traveled from that small group of circuit-riding justices whose very existence and assumed power astonished foreign observers like Tocqueville,
Right.
through national-defining conflicts over federalism, slavery, civil war, economic regulation, civil rights.
To the Warren Court's revolutionary expansion of individual rights, and the modern era marked by increasing partisanship, intensely scrutinized appointments, high-stakes cases that touch every aspect of American life, and fundamental disagreements over the court's proper role in a polarized nation.
The sources you shared really illuminate some persistent themes that continue to shape the court. The undeniable role of political considerations and appointments throughout history.
Always been there.
The dramatic changes in the nature of the court's workload and priorities, from those early humdrum disputes to its modern discretionary docket.
A huge shift.
The fundamental tension between competing constitutional interpretations and the court's profound, sometimes controversial, and often delayed impact on American society.
By exploring this history in detail, drawing directly from the specifics in these sources, you gain this essential context for understanding the court today. It's not an institution operating in a vacuum. Its present is shaped by its past struggles, compromises, and transformations. You now have a much deeper, more informed perspective on the court you see today and its place in American life.
It really makes you think about the balance of power between the branches, doesn't it? The sources mentioned John Roberts, even before he became Chief Justice, suggesting that the practical limits on the court's capacity and workload might actually be a significant check preventing the court from usurping even more of the prerogatives of the other branches. Is the court just too busy to take over everything?
It's a thought-provoking idea. Does the sheer volume of legal issues in a complex society inherently limit the court's ability to decide everything, even with its discretionary docket control through certiorari?
Or does that control actually empower it more?
Or does that control actually empower the court to exert its influence more strategically on fewer, carefully chosen issues? It's a balance that seems constantly in flux throughout its history.
And given the sources highlighting the increasing partisan alignment on the court itself, how does that historical reality, that political divides are not new, but perhaps more starkly aligned today, inform our understanding of the court's legitimacy and effectiveness in our current deeply polarized nation?
That's a critical question this deep dive helps frame, but, certainly doesn't provide a simple answer to. It's something to continue contemplating as you observe the court's role in American life today.
We hope this journey through the Supreme Court's history, drawn from these fascinating sources, has been both illuminating and perhaps sparked further curiosity for you to explore on your own.